If you DIY trademark yourself, your trademark journey could hit a roadblock if the trademark registrar cites two primary reasons for refusal: absolute and relative grounds. Don't worry, these concepts are not rocket science. The concept of refusal on absolute grounds may be slightly more complex. In gist, absolute grounds suggest that your mark itself is not registrable. We'll delve into this topic in more detail in a future episode. But for now, in this episode, our focus is to elucidate what constitutes relative grounds, why this system exists, and how crucial it is to have a brief understanding of this concept. Ready? Let's go! Relative grounds for refusal are raised if the mark is considered confusingly similar to an earlier registration. The reason we have this system is simple. If your registration doesn't prevent others from registering a similar mark in the future, why bother applying for a trademark in the first place? Trademarks that create confusion in the market should not coexist in the register. Fair enough? Understanding the concept of confusingly similar is therefore crucial. It helps you determine whether to apply for a trademark or not, and how to respond if someone opposes your application. Unfortunately, even the best IP lawyer can't definitively answer these questions. It's an art, not a science. However, specialists can use their experience and knowledge of the law to provide a good prediction, much like a weather forecast tonight helps you decide whether to bring an umbrella or not when you go for work tomorrow. We have just mentioned the concept of confusingly similar. To understand, we have to bear in mind the two major examination styles: mechanical examination and global appreciation. Picture two trademarks, ABC plus a divisive rabbit, and DDF plus a divisive rabbit. They both have two components: an English component, ABC versus DDF, and an identical device component, rabbit. Under mechanical examination, if either the English or device components are identical or similar, the pairs are considered similar, regardless of the other components. So, because our pair shares the identical device component, they are automatically deemed confusingly similar. Mechanical examination is straightforward and predictable, but can sometimes produce odd results. On the flip side, global appreciation considers the whole mark, weighing various factors against each other. For example, people usually read from left to right, so they will read ABC and DDF first, not the rabbit device. Also, words speak louder than devices, and people usually focus on the word components, which in our case are ABC and DDF. Lastly, people usually don't compare marks side by side, but instead rely on their imperfect recollection. Applying these principles of global appreciation, we could argue that our pair should not be considered similar. However, this is an oversimplified guide. In reality, the rules and exceptions are complex and continuously evolving through case laws and legislation. Not surprisingly, you'll find that no jurisdiction exclusively applies one examination style. Exceptions often arise to strike a delicate balance between certainty and fairness. So, while global appreciation and mechanical examination may produce different results, they both play a significant role in determining whether marks are confusingly similar. However, this is not the end of the story. As we navigate through the complexities of trademark similarity, it's crucial to understand that similarity isn't solely determined by the marks themselves. In fact, the products or services covered by these marks and their targeted customers also play a significant role. Let's break it down. Consider two marks that cover products or services in different categories, say, bags under Class 18 and fashion under Class 25. While these are distinct classes, they often share the same trade channels. Many shops sell both bags and fashion items together, targeting the same caliber of customers. In this scenario, even if the marks aren't identical or strikingly similar, they could still be considered confusingly similar due to the shared trade channels and customer base. Now, compare this to a scenario where one mark covers medical equipment under Class 10 and another covers fashion under Class 25. These two categories are virtually disconnected, with distinct trade channels and targeted customers. So even if the marks are somewhat similar, they may not be deemed confusingly similar due to the stark differences in their trade channels and customer base. In some jurisdictions, to help discern whether products or services are similar, trademark offices issue guidance or adopt a subclass system. However, these rules and systems are still subject to interpretation and discretion. They also rely heavily on the arguments presented by your attorney. We've navigated the complex terrain of trademark refusal on relative grounds today, exploring the concept of confusingly similar, and dissecting the role of trade channels and targeted customers in determining trademark similarity. The key takeaway? Understanding these concepts is crucial for successful trademark registration. The world of trademarks is intricate and ever-evolving, and it's our mission here at Trasomark channel to help you stay informed and prepared. So join us as we continue exploring the fascinating world of trademarks. Stay tuned with Trasomark channel for more insights into the world of trademarks. We look forward to seeing you in our next video.